Good morning, everyone. We're just going to wait another moment or two to allow everyone to get in from the waiting room. And that looks like that's everyone. Good morning. Welcome to our Wednesday Q&A. Just our usual brief Zoom housekeeping tips. You will find your mute and unmute and stop video or start video button on the bottom of your screen, depending on which platform you use. We ask that everyone stay muted to reduce background noise. Please keep in mind that the chat function is for asking for clarification or asking a question. It is not meant to be a discussion such as you see on the CAI message boards. The chat is not legal advice. We do not give legal advice in this forum. We cannot do that because we don't have your governing documents and don't know your specific community. If you have a question that requires legal advice, you can send it to your regular association counsel. If you don't have an association counsel, we recommend that you get one before you have a problem. That way you have that relationship already, and when an issue comes up, your counsel is good to go and ready to start working and helping you. The CTA is still being challenged in the federal courts. We recommend waiting to see where that falls. The CTA requirements don't come into you're not late, let's put it that way, until January 1st of 2025. So later this summer, in the fall is probably when we really need to start deciding if you're going to report or not. I can't remember, and Kathleen, I see your question. I can't remember off the top of my head. Ken, do you remember what CTA stands for? It's the
Corporate Transparency Act.
That's right.
It's where the federal government wants the very detailed contact information for the decision makers for every type of LLC or business entity.
If you want more information regarding the Corporate Transparency Act, I know late April, early May, we had a bunch of questions on it in one of the Q&A sessions. So if you go on to our YouTube channel, you should be able to find it. These Q&A sessions have been recorded since we started back in April of 2020. So if you want to find more information about a topic, you can go onto our YouTube channel and find the information there. There's a search function just for the YouTube channel.
Yeah, I also would suggest for the Corporate Transparency Act, there's going to be so much regarding that from the national CAI and on Google searches that probably in about September people should be looking again, because there will be more clarity about whether the associations are exempt because they are nonprofit 501 C4 entities, or whether or not the statute is postponed in its implementation date, or whether or not the statute is revised, because there's a lot of effort on the East Coast to try and make those changes.
So one last Zoom one last thing that we've been talking about for a while. A number of revisions to WUCIOA will take effect on June 6, 2024. If you are a WUCIOA community, you should be aware of these. The revisions are not currently available on the legislature's website. They haven't been physically added to the statutes. Like if you just search RCW 6490, you're not going to see those changes. It's still in the House bill. So statutes for records, notice, and voting no longer match as they have for the past 9 months. So if you are a WUCIOA community, you really need to take a look at these. They take effect next month. If you're not a WUCIOA community yet, just be aware that these are coming, because in 3 years, if our legislature doesn't change it again, they will become effective again, effective for you. So moving on to the next question, to the first question. Can a spouse that is not on title vote on behalf of the unit, or does their name actually have to be on title? So this is a question we get fairly often. Washington is a community property state. It's a safe assumption that if 2 individuals live in the same unit, apartment, lot, whatever, and hold themselves out as married, they're married. Either spouse can vote for the unit. Excuse me. One of the changes in WUCIOA that become effective in June is that some changes to the proxy language. So when a unit owner votes by proxy, the association shall implement reasonable measures to verify the identity of the unit holder and the proxy holder. We don't know what this means. We don't know what a reasonable measure is. So this is going to be interesting. What we do know, and what we have been telling our clients for years, if somebody holds out that they're married, you really don't need to search marriage records or require both spouses to be on the deed, which typically requires them to redo a mortgage to add someone to a deed. If you have someone challenging an individual's ability to vote, you can have the owner who is on title sign a proxy allowing the individual who's wanting to vote for them. You can also ask them to sign a document stating that they make this individual their agent for purposes of voting for the unit. So there are a couple ways to do this. You don't have to search marriage records. We honestly don't recommend doing that, because while it is public record, it's more information than you really need to look at. Just whatever is reasonable. If someone says that they're married, they are. Ken, did you have anything to add to that?
No, I'm good on that. Thanks. So the next question is regarding reasonable care. In the lawsuit, Riss v. Angel, which is a landmark case from Washington State, individual directors and homeowners voting to prohibit the owner's construction were held personally financially liable for not acting in a reasonable manner. This involved construction. Can you speak informally of other types of actions or unreasonable care by directors that resulted in legal action? So there is a fairly regular string of lawsuits that occur in Washington State. I would say most of them relate to application of architectural control, or the boards prohibiting the addition or modification of the garages or additions of sheds. Other issues which come up fairly frequently involve views and what trees are doing to impact views. Cases come up that relate to the use of property, often accommodation of businesses, or some kind of a commercial use of a residential property, which is being either allowed or not allowed by the board of directors. And then there have been some which relate to short-term rentals or Airbnb kind of cases. But I would say there's not a limit to the kinds of things which the board can get sued for, but those are the ones which kind of come to mind. Do you have any other thoughts, Jennifer?
Just briefly, boards have a statutory duty of care to act in a reasonable manner, in the same manner a reasonable person would, with the same level of investigation that a reasonable person would. Risk v. Angel should be looked at its facts. The facts seemed to be pretty much self-dealing by certain board members to prevent construction on a lot in their community. So our typical advice to our clients is, as long as you're acting reasonably in a reasonable manner and have a reasonable basis for your decision, courts likely won't overturn your decision. And people can sue for anything. It's extremely rare for it to go to the appellate courts where people actually take notice, and courts are more likely to be firmer in their decision. So next question. Our declaration provides criteria for owners to vote. An owner may not be delinquent in monthly assessments, special assessments, or violation penalties, have no liens or legal actions pending between the association and the owner. I recall from an earlier Q&A that associations may not restrict owners from voting. Is that correct? So this is for current WUCIOA communities, and then everyone after January 1st, 2028. The actual statutory reference is 6490-405 sub 2 sub X 2. And it states that the association cannot suspend an owner's right to vote. So our general recommendation now for communities is to not restrict owners from voting. There's no evidence to support the idea that suspending voting rights does anything to benefit the association, especially when apathy is high, and most associations have problems getting enough owners to show up and vote in the first place. So suspending the right to vote for the association is counterproductive, and you want owners to be engaged. We recommend not doing that. If your declaration or governing documents currently have that restriction, you may want to look at amending to remove that. Ken, did you have anything to add?
Yeah, the goal, if you're trying to reach quorum, is going to be more difficult if you start prohibiting owners from voting, because it's not that you get to reduce the total count pretending those votes don't exist to have a smaller quorum. You still need the same size quorum. So next question is, why would bylaws require officers of an association to be Washington state residents? So there's certainly no requirement under any state law that board members or officers be residents. We do have some clients that have added that kind of language to their documents because they feel like, being president or treasurer requires you to be physically present to sign checks or sign contracts or otherwise perform your duties. So we have a number of clients that have residency requirements either to reside in the state or even to reside within the community for their officers, but there's no legal requirement. Second part of the question is it correct that a non-Washington resident can serve on the board, but just not be assigned to the office of president, secretary, treasurer? That question is really specific just to the individual document that you have, your bylaws or declaration or articles of incorporation. So some would require all board members to be residents, even though the statute doesn't. Apparently, this particular set of documents requires only officers to be residents. And there is a reference to the Nonprofit Corporation Act, which is 2403A.500, which does state specifically that a director of a nonprofit corporation may live in any other state unless the articles or bylaws have something different. Anything you want to add, Jennifer?
No, and I saw a quick question in the chat referring back to the question about spouses being on title. And the question is, can a married spouse not listed on the lease run for a board position? It depends on your governing documents. If your governing documents have the language that all board members need not be owners, or a majority of the board must be owners, then anyone who's a resident in the community can run for a board position. It would really depend on your governing documents. Ken, did you have anything to add to that?
No.
Okay. So the next question, and this is a quick one, on May 8th meeting near the recording point 5702, it was mentioned that a board cannot change the qualifications for an owner running for the board due to the statute stating such. There is no mention on which statute. This particular community is under 6432, and they don't see this reference in the statute in 6432. And that is correct. This language is actually in 6434, 6438, and 6490. Those particular provisions, 6434, 308 sub 2, that particular provision of 6434 has not been made applicable to the old act. 6438 025 sub 2, 6490 410 sub 4 sub E, and that particular statute, the 6490 410, will be applicable to everyone starting January 1st, 2028. So while this language is not applicable to the old act right now, it will be in 3 years. Ken, did you have anything to add to that?
Yeah, so an example of a qualification which some boards might want to impose would be to prohibit a delinquent owner from running for the board. And if your documents don't already have that as a provision, the board alone cannot add that as a qualification to serve on the board. The membership as a whole can add that as a qualification, but the board alone cannot do it. Next question. Our board is debating whether or not to share with the membership the law firm's review of our covenants. The concern that was voiced is that once an attorney-client privilege is waived, then the board would be required to share any future attorney responses regarding covenant questions with the membership, even if those responses were of a more sensitive nature. Is there a way to preserve attorney-client privilege for future questions if our attorney existing comments are shared now? So there's nothing which would create a right to view new information from your attorney if you share a past legal opinion. So I'm not sure why someone thinks that you've sort of opened the door or Pandora's box for all legal opinions or all opinions about the covenants by sharing one opinion. You are not. So the board gets to protect, if it chooses to, the privilege of any new information that comes out. Basically, the board of directors as a whole has the right to choose to waive the privilege, not individual board members. And so if you have a privileged document, a person who leaves the board is not allowed to share it. One board member is not allowed to share it. It has to be a decision of the board, which should be reflected in the meeting minutes, to share an opinion with the community. And that's the extent of what you're sharing. The privilege would continue for any new information, and you could make a separate decision in the future. Anything you want to add, Jennifer?
No. Next question. So this was a long one that was sent. We greatly condensed it. Any general comments are appreciated regarding the newly enacted Fannie Mae Freddie Mac maximum allowable deductible for condominium master policy. So what this refers to is a new ruling from Fannie Mae and Freddie Mac regarding insurance deductibles. We haven't done extensive research. We're not giving legal advice. We really recommend you speak with your individual insurance carrier. It appears that this language is involving specific insurance deductibles for specified perils such as windstorm, water or rain, etc. Federal lending requires the separate peril deductible to be 5% or less of the total insurance coverage. So this is total building coverage, not one unit. So some associations already have a separate deductible amount for water losses. The language from Fannie Mae and Freddie Mac does provide that the individual unit owner policy can cure the problem if the association's deductible is above the 5% or is more than 5% of the total insurance coverage. So this is really fact specific. Check with your insurance carrier. And that's pretty much all we can comment on this. Ken, did you have anything to add?
I'll just offer that we have not had any any calls come into our office saying that a community was unable to have their owners get mortgages because of the insurance deductibles that are in the policies that they have. So this may be a rule and regulation which just doesn't ever impact our client base. And so I sort of applaud somebody finding a new rule out there, but I don't think that it's going to matter because it is a building total deductible in the same way that earthquake policies will often have a deductible of, 2 to 5%. This is related to policies which have large deductibles for what are potentially large losses in order to protect the insurance company. And it's the losses we're seeing don't relate to hailstorms, which is apparently what the Fannie Mae is dealing with. Ours usually relate to water losses. And even if you've got a large deductible, like $50,000 or $100,000, for the building, it's probably still well under the 5% threshold because it's 5% of the building value. If you've got a 10-unit condo where the reconstruction cost is, $400,000 a unit, that is a $4 million property. The deductible at Fannie Mae's maximum would be $200,000. So you're not anywhere close to that for most of our clients. Next question is, a homeowner requests to opt in to electronic notification. Are they considered to be officially notified for any association business if they are issued only a mailed notice to their primary mailing address, no electronic copy delivered? So the short answer is going to be yes, because notice is always effective if it's sent to the owner's mailing address as provided to the association. Many of the governing documents do provide that if you mail it to the unit address, that's adequate. It's so electronic notice is an opt-in. The association can send notice through the mail as well. There are some types of notices that relate to delinquencies and foreclosures, which must be delivered by mail and must be delivered to the unit address in addition to any other mailing address on record. We often recommend using both methods of notice because you're trying to increase the likelihood of it actually being effective. And one of the things that we're also looking at, and sometimes courts will consider, is whether or not the association took reasonable efforts to actually make notice. So there's at least one case where a judge refused to allow a foreclosure in a case where the management company had a telephone number for an owner and had never attempted to call the owner to tell them that the unit was delinquent and was going to go into foreclosure. And the court felt that that was not fair, that the association and manager had not taken reasonable measures to make contact when they had contact information. So it starts to get really specific. And I guess it starts to depend on the specific type of notice that you're dealing with, how important it is that you attempt more than one method, or how you comply with the notice provision. Anything you want to add, Jennifer?
No. Moving on to the next question. This is going to be a long one with multiple parts. Can association residents stage peaceful protests on the grounds of the association? Probably. There's nothing in most declarations that would prohibit any kind of gathering on common areas. Next part of the question, protests with bullhorns, picket signs, walking in the community streets, possibly blocking them during protest. There's too many variables here to give a specific answer. Are these streets public or private? What kind of noise ordinances or rules does the association have? So the association can regulate noise and behavior in the common areas, but just because you can doesn't mean you should. You need to consider whether or not the association wants to be on the news over efforts to enforce. So associations have been deemed to be quasi-governmental, and the First Amendment, freedom of speech may still apply. We pretty much recommend taking a strong look at this if this happens, on whether you should enforce or whether there's something else going on that needs to be addressed. So next part, can an association take a specific yes/no position on a matter like building of a cell tower on the behalf of the entire community, even if there are members of the community who may take the opposite position on the matter? And probably the board can make decisions that some owners don't agree with. Individual owners can ask the board to change their opinion or petition the governmental, if there's a governmental agency involved. Individual owners can petition that governmental agency. If the construction is on common property, the board probably has the exclusive authority to permit it. So individual owners cannot prohibit actions by the board regarding common property. So last part of this question is the association prohibited in any way from writing letters in support to city councils or other governmental agencies to express their support or lack thereof, stating they are representing the entire community? So the answer to this one is no. There is no prohibition on the association taking a position. The board acts by and for the association as a whole. The letter in support is from the corporation, the board, not the individual owners. Individual owners can have other opinions and make their opinion known to governmental agencies. If this particular situation happens, we would want the board to be able to articulate why support for some proposition was beneficial to the entire community. And this is different than making a donation to some political cause. Ken, did you have anything to add to that?
Well, I'll just offer that when you start getting into issues that are political or issues that relate to municipal improvements, you may want to get more specific information to an attorney to help advise you. And I think we even have some communities that have public relations professionals who work with them to try and manage both internally how they are expressing their public comments, and then to work with the government entities as well. It's in some respects, it's similar to CAI trying to speak on behalf of every community association. And, we've got a legislative action committee that is going down and telling the legislature that we support or don't support different actions. And there's no question that the legislative action committee is not representing every opinion for every community. And so the board certainly does have some authority. We just would want to essentially say you're speaking for the board on behalf of the community. You're not speaking on behalf of every owner. And I think it's okay. There should be a way for a community, especially a large community, to influence the government in decisions that it's going to make that have an impact on the community. Next question. At last week's meeting, I believe it was Valerie who laid out a clear path to early adoption of WUCIOA with a minimum required owner participation. I looked up the statute 6490.095, which states that the governing documents, if they don't contain a provision for amendment, would use the amendment procedures from this chapter, meaning WUCIOA. Our CC&Rs have a 75% requirement for amendments. I don't see any wiggle room to allow us to use less than 75%. So the answer is that under RCW 6490.095 subsection 3, it starts with the statement, notwithstanding any provision in the governing documents. So this is a fancy legal phrase, which basically means the legislature does not care what your documents state. Doesn't matter what your documents state. The notwithstanding means we don't care. This provision allows you to use a 30% participation with 67% voting in favor to adopt WUCIOA. So notwithstanding wipes out the 75% requirement in your document for the purposes of adopting WUCIOA only. It does not change the requirement for any other kind of amendment in your document or by statute. So, anything you want to add on that, Jennifer?
No. The next question is, what are a condo board member's legal obligations for resigning from the old Act condominium board? For example, turning over records, hard copies, digitals, turning over names and addresses of contacts, etc. So the only statute that addresses records for old Act condos is 6432-170 sub 9. And this addresses records kept by management companies, not individual board members. So the legislature hasn't really taken into account an individual who wants to withhold records from the association when they're off the board. The duty to retain records is on the association. But one way that may be helpful, this is in the Nonprofit Corporations Act 2403A 2020, excuse me, 220. The scope of members' inspection right, this is for a member to inspect records. So the entire section, meaning 2403A 220, this section does not affect the power of any court of competent jurisdiction independently of this chapter to compel production of corporate records for examination. So what this means is that if you have a board member that's refusing to turn over association records, you can ask them to turn them over. You can try to recreate records. And then also you can sue and have see if the court will order the individual to produce records. Question for the reference, it's 2403A 220. Ken, did you have anything to add?
Well, in your notes, you had said that this is a good reason to try and create a central repository for all of your association records. And we've seen a number of clients who've moved to having all of their documents on a central website, which the membership has access to. And that's I would say a good way to solve this problem. We have had fewer incidents recently of the angry board member quitting and refusing to give all of the information to the new board members, but it certainly could happen. And as you said, the legislature was not designed to address an owner who just refuses to do something. And so we would normally suggest first, try and find someone who's on reasonably good terms with the resigning board member to, persuade them to produce the documents, recreate the documents if you need to. But we've, certainly had clients where a treasurer has left office and refused to provide all of the financial records from the past. And that has been a challenge for the community. And short of litigation, and I think you'd be suing for the board members or former board members' failure to comply with their duty of ordinary and reasonable care. But short of litigation and getting a court order, there's not a statute which can force it. So you need to try and work with your former board member rather than against them. So next question, in regards to 649410, maybe the question will answer it. Assuming that the association is governed by WUCIOA and that there are no provisions provided otherwise in the governing documents, at the transition, it says the board must be comprised of at least 3 board members, a majority of whom must be unit owners. But the number of board members need not exceed the number of units in the community. So if you have a 2-unit community, you don't have to have 3 board members. Does this mean if the board of directors is comprised of 3 members, only 2 of the 3 must be unit owners? And the answer to that is yes. It means only 2 of the 3 must be unit owners. Next question, is it permissible for a non-owner to be seated on the board by either election and or appointment due to a vacancy? And the answer is yes. If your documents do not prohibit non-owners serving on the board, the statute allows non-owners to be appointed or elected to the board. Okay. And you might have non-owners because they are tenants or relatives of the legal owner. You might have non-owners because they have some particular expertise. They're your accountant, or they're your manager, or they're your attorney. So it's certainly possible for the membership to elect the person of their choice if the governing documents do not restrict who can serve on the board. So any other follow-up to that, Jennifer?
No. So the next question is, for an over 55 condominium community, the HOPA survey, do residents have to provide copies of their documentation, or can they present it to a board member for examination without it being copied? Does a resident self-certification affidavit have to be notarized? So what this means is HOPA is the Housing for Older Persons Act. This is the federal statute that allows 55 and older communities to restrict living in the community to individuals 55 and older. The statute requires that at least 80% of the community, of the individuals living in the community be 55 and older. So at least 1 resident in each individual lot, unit, what have you, must be 55 and older, and 80% of those would apply. So that, and the statute requires that every 2 years a census be taken of the residents in the community to ensure that you're still meeting the 80% 55 and older. There is a risk that HUD will ask for proof of the HOPA eligibility. If you don't have copies of documents or a statement from a household member, it could lead to removal of HOPA status. We have had associations make an application affidavit or other document signed by an adult member of the household asserting that at least 1 occupant of the unit is 55 and older. That satisfies this requirement. The self-certification satisfies HOPA on the HUD website. A self-certification such as a signed lease, the signed document, or an affidavit stating proof of age or at least one member of the household is 55 and older. Notarization probably will satisfy the requirement, so notarization probably isn't necessary. But just in at least 80% of the living dwelling units, however you want to use that term according to your governing documents, in at least 80%, one individual has to be 55 and older to qualify. Ken, did you have anything to add to that?
Yeah, so the first part of the question is, do the residents have to provide copies of their birth certificate or driver's license? And I'd say the answer is no, if the person doing this, the survey or compiling the survey can say what document they used as verification that the person was indeed over 55. A written sworn statement from the owner satisfies the requirement. So that may be the easiest thing. If they don't want to give you their driver's license, just have them sign the form saying that they're over 55. If they don't do that and you've seen their driver's license, the person preparing the document could say that they saw the person's driver's license confirmed they were over 55. But again, the likelihood of someone coming to you and demanding the actual proof is fairly low. HUD does not monitor this on a regular basis. Next question. Can you speak to the decision of the appellate court in case number, long list of numbers and letters, regarding the display of political yard signs? The court appears to dispel that an HOA can regulate political yard signs before an election, but then fails to define what can be interpreted as before. This leads to thoughts that the day after an election is still before the next election. Okay. So a couple comments. One is that we could argue that the Division II appellate decision isn't precedent for anyone outside of Division II. I think that'd be a mistake personally. It was decided on the current language of the Homeowner Association Act, which does not include a time element for what the board can do. I will note that effective on June 6th, the WUCIOA was edited to also remove the time restriction so that there will not be under WUCIOA the ability to regulate time as was discussed in the court decision. So I think that it's not reasonable to conclude that the day after an election, someone is on the ballot again. So I think that you can wait until someone is at least a declared candidate for some kind of election, or an issue is actually on a ballot. But again, we would caution if it's something like the No Iraq War or Black Lives Matter or something which doesn't really have a timeline, we would still recommend that you consider how the public is going to perceive enforcement efforts and maybe get some advice from a manager or an attorney on whether or not it's a good idea to try and regulate, even if you did have the authority to regulate. And I think it's also important that you probably have to have some kind of written rules regarding the placement and manner of display for the political signs, whether it's before or after. And I guess that's all I've got, unless you have something else to add, Jennifer.
No, I don't. And it looks like we're almost done with our prepared questions. So if you have any questions that you want, that you've thought of in the last hour or so, or something came up, please put it in the chat and we'll see if we can get to it. So the last question we had prepared is, do we know the status of the current no open flames fire code for condominiums? And we don't provide legal advice on the fire code. The research that we have done To our knowledge, this provision of the International Fire Code was not adopted by Washington State. So statewide, it's not in the WAC. But individual cities or counties may adopt stricter standards. So you want to check with your city or county's codes and see if they have something different. You can also check with your local fire marshal or your association's insurance carrier for their recommendations as well. Ken, did you have anything to add to that?
Nope, I'm good on that. Do we want to cover, well, sure. We had a question that came in through a different channel, which wanted to, it was from a management company, wanted to confirm that if they posted a proxy on their website for all owners to sign electronically and submit to the property manager, that that was going to be adequate for all of their communities. And the answer is that we can't tell you it's adequate for all of your communities because the individual CC&Rs or declaration or bylaws or articles of incorporation all could have restrictions on how proxies are used and how proxies are adopted and whether you can even vote by proxy. Because it is possible under the statutes to prohibit proxies. We see it rarely. We don't know why you would want to do it, but it is possible to require that owners vote in person. And so to just post a proxy on a management website is, you know, we can't tell if that would be adequate or not to serve for an individual vote. We also now have the challenge of the WUCIOA having been amended, which was our first question today, to require some reasonable verification by the association that a proxy has actually been executed by the owner. And we don't know how you would do that, or if you would be doing that by posting a proxy on a website and allowing them to be signed electronically. So there's going to be some fallout based on, I think, the new voting statutes, which have taken effect the last 2 years, and this revision to WUCIOA, which is taking effect in June. I have to think there's some conspiracy theorists who are talking with the legislature, getting some of this language in because they're concerned about people somehow cheating the elections and votes that are happening within the communities. So with that, unless you have something to add, Jennifer, we can look at whether or not any questions have come in the chat.
I didn't have anything to add, and there are questions in the chat. So the first one that I found, are there requirements for reserve accounts to be FDIC protected? And the general answer is not unless it's in your governing documents. However, the board is required to act reasonably, especially when it comes to other people's money. So it's what's in your governing documents and what risk the board believes is acceptable. Ken, did you have anything to add to that?
Well, I'm going to add to that some confusion because WUCIOA defines what a certified financial institution is. And it does define a certified financial institution as one which has federal insurance for your deposit accounts. And then when it talks later in the statute about the reserve account, it says it must be in a certified financial institution. So if this is being read strictly, it would mean you could not have an account with Fidelity or any other kind of investment banking institution with a deposit account or any other kind of investment that was not federally insured. And some of this starts to not make sense. So for example, it would mean you could not buy a treasury bill from the government because they are not federally insured. They are backed by the government, but they are not federally insured. It would mean you could not have an investment in a mutual fund, even if it was done with advice of a financial advisor as part of a balanced portfolio, because it is not federally insured. So we don't know why the legislature stuck in this definition of what a certified financial institution is. When they adopted WUCIOA, we have not seen it challenged yet, but it is a question.
So the next question from the chat. An association has not done yard work in 15 years, and now the board wants to enforce a rule. Is that okay? The backyard common areas are completely overgrown. The homeowners planted in the area. Is it okay to have homeowners pay for the removal of all these added trees? This is a little specific. It would really depend on what's in your governing documents and what's reasonable.
Jennifer, I would try and recast the question as, can an association begin to enforce a rule or covenant which has been largely ignored for several years?
Our typical answer is it depends. You can send notice out to all the owners and inform them that the board is going to start enforcing this particular provision. Requiring owners to remove a tree gets a little hairy. Especially since, depending on the size of the tree, is it something that's going to require a permit from your local governing body?
Yeah, I could also see a lot of different opinions about whether or not trees within one owner's yard should be governed or managed by the community. And when you talk an overgrown yard, usually people don't think of trees, they're thinking about weeds, but I think it is possible for communities to enforce covenants which have been largely abandoned. It requires time to re-educate your members about what the covenants are, why the covenants exist. And when you switch to the question of, can we just make the owner pay for us going in and fixing it all, I think you're going to be many months in a process to try and do that in a way that an attorney would be able to successfully defend your making that an owner expense. Any others, Jennifer?
There's a question that was turned down due to being too specific. Maybe we have time to cover. There's a stormwater wet vault of a size where cleaning would cost around $400,000. Have we worked with any governing authority to negotiate this kind of thing or alternative methods? That is too specific for us to answer.
Well, it is too specific. We have had clients that have worked successfully with the county, which is trying to manage and regulate the stormwater, in order to find alternative ways to deal with storm vaults. And the stormwater retention vault is usually something that's like under a road. It's designed to hold a lot of water and then filter through the bottom of the vault down into the ground to reduce the runoff into the county's stormwater system. And over time, the bottom of the vault tends to fill with silt. And so it doesn't percolate the water down the way it's supposed to. And so sometimes you have to dig out all the material and put in fresh sand or gravel. But it is certainly something where most of the counties are willing to discuss alternative ways of accomplishing an end result rather than simply tearing out and putting back in what was there originally. So it's worth trying to talk with your government regulating official and see what you can do, because I would say in most cases they are reasonable and are trying to accomplish a purpose, not just require compliance with an arbitrary rule.
And I don't see any further questions. Oh, here we go. Our association president, who is chosen by the board, has been arrested and is facing an assault 1-degree charge, as well as other firearm charges. Can the board remove him ASAP? No.
Well, the
The-
board can remove him from his position as an officer. They just can't remove him from the board of directors because the board doesn't have that authority.
And the vote must come from the board of directors. It can't be done by 1 or 2 individual officers. So the board as a whole votes to put officers in position. They can also vote to remove someone from their officer position. Only as the association as a whole can vote to remove someone from the board. And we are at 10:57. I don't see any further questions.
Well, we can all rejoin next week and discuss more questions.
Have a good week, everyone.